Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm going to discuss something that many plan administrators might not think about as much as perhaps they should, and that's forfeitures in defined contribution retirement plans, especially 401k plans. So, what is a forfeiture in a 401k plan? When does that happen? A forfeiture in a 401k plan happens when a participant terminates employment before becoming fully vested in employer contributions. So if the plan provides for matching contributions, profit sharing contributions, non-elective employer contributions, those types of employer contributions usually have a vesting schedule. And when an employee terminates employment before becoming fully vested in those contributions, the money goes into a forfeiture account. And those forfeitures occur really when the participant receives a full distribution of their vested account balance or after they've incurred 5 one-year breaks in service. And so at that time, there is money that no longer belongs to the participant. It's been forfeited and it moves into the plan's forfeiture account. And so what can an employer do with those forfeitures? Well, normally a plan will provide that the employer may choose to use the forfeitures to pay for plan administrative expenses and or use the forfeitures to reduce future employer contributions. So if there's $10,000 in a forfeiture account and the employer has to make a $100,000 matching contribution, $10,000 can be moved out of the forfeiture account, applied toward the matching contribution, and the employer only actually contributes $90,000 for that year. So that's one use of forfeitures that are typically allowed under plan documents. And in fact, the IRS just last year issued proposed regulations regarding the use of forfeitures. Under the proposed regs, these haven't been finalized, a plan document must provide that forfeitures will be used for one or more of the following purposes. They may be used to pay plan administrative expenses. They may be used to reduce future employer contributions, or they may be used to increase benefits in other participants' accounts. So last year, the IRS proposed regulations are really consistent with what most plans already provide and really give you some comfort, right? That what your plan document provides regarding forfeitures is correct. And the IRS guidance also provides that the forfeitures must be used no later than 12 months after the plan year in which they occur. So that requires plan administrators to be on top of this and make sure that the forfeitures are being used on a timely basis for one of those three ways you can use forfeitures: plan expenses, future employer contributions, or to increase benefits in other participants' accounts. And so that seems pretty straightforward, right? This is what we've always thought was the case. This is what we've been doing. We've been using forfeitures. Often I know clients use forfeitures to offset, future matching contributions or profit sharing contributions. Well, that's what you think. But very recently, there has been a wave of litigation regarding the use of forfeitures in ERISA fiduciary duties. So these employers have been sued. Qualcomm, Clorox, Thermo Fisher, Mattel, and John Muir Health have all been sued, asserting that plan fiduciaries misused plan forfeitures. In all of these cases, the plan documents had the typical language that allowed forfeitures to be used either to pay plan administrative expenses or to reduce future plan contributions. And guess what these employers decided to do? They used the forfeitures, as the plan document permitted, to reduce future employer contributions. So they have that $100,000 matching contribution they have to make. They only make $90,000, and they pull the $10,000 out of the forfeiture account to make the full matching contribution. So the plaintiffs in these cases asserted that that decision breached ERISA fiduciary duty, that the forfeitures were being used for the benefit of the employer instead of for the benefit of participants. So their claim is, employer, you had to make a $100,000 matching contribution, and instead you chose to use plan assets to reduce the amount that you had to contribute to the plan. So you contributed $90,000 instead of the full $100,000. The plaintiffs also allege that this is a misuse of plan assets to the extent that it's a prohibited transaction, that parties in interest were using plan assets for their own benefit, that in making this decision to pay for future plan contributions instead of to pay plan expenses, the fiduciaries failed to discharge their duties solely in the interest of plan participants. They failed to discharge their duties for the exclusive purpose of providing benefits to plan participants. And plan assets, those forfeiture accounts, impermissibly were used for the benefit of the employer. In addition, the plaintiffs allege that the plan fiduciaries failed to engage in a prudent process to determine if they had a choice under the plan document to either use forfeitures to pay plan expenses or to pay for future plan contributions. There was no record of plan fiduciaries making a prudent, diligent analysis of what the best result would be for plan participants, whether to use it to pay plan expenses or to use the forfeitures to offset future employer contributions. So this is a kind of a novel claim here, fiduciary breach, prohibited transaction assertion, when we've all understood that we can use plan forfeitures to pay plan expenses or to offset future employer contributions. It seems to be a little tenuous given that plan documents have always allowed this, that the plan fiduciaries were following the plan document, and therefore we would never have thought this would be an issue. In fact, just last month in the Hewlett-Packard case, the court dismissed the class action asserting breaches of ERISA fiduciary duty with respect to the use of forfeitures. In May, however, a judge in the Southern District of California did not dismiss the case, and now Qualcomm has to prove that their use of the forfeitures was consistent with their ERISA fiduciary duties. So there's a little inconsistency in the rulings so far in this area. And so it is an area that plan fiduciaries really need to pay attention to now that this litigation is underway. So what can you do if you're a plan fiduciary, an employer that has a 401k plan? Well, first thing that you should do is review the plan document, and you need to know what the plan document says about forfeitures. Most likely your plan document allows the choice between using forfeitures to pay plan expenses or using forfeitures to offset future employer contributions. But you need to know that. So you need to make sure that what you have been doing so far with forfeitures has been consistent with your plan document. But then with this ongoing litigation, a way to shield the employer and plan fiduciaries would be to amend that forfeiture provision to, for example, require forfeitures to be used to offset plan contributions first, and then used to offset plan expenses second. If this is what the employer intends to do with forfeitures, amending the plan is not a fiduciary function. It's not subject to ERISA fiduciary duties. And once the plan has this rule hardwired into it, it takes the fiduciary discretion off the table. And so it would no longer be a fiduciary decision as to how forfeitures should be used. It would be a requirement under the terms of the plan that the forfeitures are used in this way. So one more thing to add to the list for plan sponsors, fiduciaries, and plan administrators to think about. I encourage, again, plan sponsors to know what their plan documents say and really analyze whether some changes to the wording of the plan would be in the best interest of the plan and the employer to shield off a potential fiduciary breach claim. That'll wrap up my discussion of the current state of forfeitures in 401k plans. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.